Hello, and welcome back to Litigation Corner, where we talk about legal issues that impact real people in our communities and discuss how you can access and navigate the legal system, even without a lawyer. I'm John Martino, the Director of Litigation at Community Legal Services. Today, we're focusing on a powerful legal tool that can help save lives: domestic violence injunctions. If you or someone you love is in an abusive relationship, there is help out there. There is protection available, and it's okay. In fact, it's brave to ask the court for help. So today, we're going to give you a guide on how to obtain an injunction to protect someone from domestic violence here on this episode of Litigation Corner. Let's start by breaking down the term injunction. The term injunction is really a legal term for what is more commonly referred to as a restraining order. The injunction is a court order that can require the person to stay away from you, your home, your job, your children. It can give you temporary custody and temporary child support. It can stop an abuser from contacting you altogether. An injunction is just a piece of paper. It's not a shield, but it does carry the full power of the law, and for many survivors, it is the first step in reclaiming their lives and securing their safety. I say this from a place of experience. For nearly 5 years, I worked as an assistant state attorney in Volusia County, and no cases meant as much to me as domestic violence and child abuse cases. When I transitioned my career to civil law, I joined Community Legal Services Family Law Unit, which helps survivors of domestic violence secure injunctions. I have been there with survivors as they have expressed their fear of reprisal if an injunction is denied. I have been there sitting next to a survivor while they testify about violence and dehumanizing condition, and I have seen the relief in their faces when an injunction for protection is ordered. This video is meant to inform you how to effectively file for and obtain an injunction and get the relief so many out there need. Let's start with some definitions. Petitioner, the legal term for the person who is being abused and who files for the injunction. Respondent, the legal term for the person who is the alleged abuser against whom the injunction is sought. Temporary injunction. A temporary injunction is a temporary protection order in place from the time that the petition for injunction is filed until a final hearing is held. And then a final injunction is the final order of protection granted after the hearing. So, how do we get an injunction? The process begins with filing a petition. That is a written request to the court explaining what's been happening. And here is some good news. The Florida Supreme Court has a form to follow, so you have a better idea of what to include in your request. The petition is your chance to tell your story in your own words. And I want you to remember, be thorough, not rushed. Take your time. Use specific examples. Include dates, even if they are approximate dates. If you do not know an exact date, try to find it out. And if you are still unsure, you can indicate that you are providing an approximate date. Describe each and every incident clearly. What was said? What happened? How did you feel? You cannot just attach a police report. Normally, the court is most concerned with recent activity, but you should include every major incident of physical violence, verbal threats to your person, and injuries that have taken place as a result of the violence. If you run out of room, don't worry. You can attach additional pages. And don't be afraid to ask court staff for help locating the forms. They usually have copies of the form available for these purposes. It is advisable that you write out a timeline or narrative before you get to the courthouse. If you forget an incident, and it is not included in or attached to the petition, then you cannot discuss it later in court. Also, it can be stressful to write about these incidents in public, around other people that you do not know. Keep in mind that the state attorney's office, law enforcement agencies, and domestic abuse shelters have kind, supportive people available to you, usually called victim advocates. These advocates will often accompany you to the court or sit with you while preparing your petition. They are generally not lawyers, so they cannot give you legal advice, but they can provide you with support and encouragement. And they know a thing or two, since they are often in court more than the lawyers are. What you write in the petition helps the judge understand your situation, so be honest, be clear, and most importantly, be safe. There is one form that you have to fill out with the petition that I want to make sure you are aware of, so you're not surprised. It is called the petitioner's waiver or non-waiver of return hearing. Basically, it asks you whether you would like to still have a hearing even if the temporary injunction is denied. This means that if the judge decides to deny the request for the injunction from the abuser, then the person will not receive any notice that you tried to get the injunction against them. However, you can also request a hearing even if the temporary injunction is denied, and in those circumstances, it is possible that you may be able to convince the judge at the hearing that a final injunction is still necessary. Now let's talk about how you get the temporary injunction. Once you file your petition, a judge will usually review it on the same day. If they believe you're in immediate danger, they can issue a temporary injunction to give you protection right away. This order goes into effect before a full hearing happens. It usually lasts until your court date, usually within 15 days. This means that you get protection quickly. The respondent, the other person, will be served with the order and told not to contact you, and then you get ready for your hearing. So what happens at the hearing? You'll be in a courtroom with the judge and the respondent. Don't let that intimidate you. This is your moment to speak the truth. The respondent will be there, which can be terrifying, but so are lawyers, law enforcement officers, and the judge. Plus, everyone will be checked by security as they enter the building. The judge will start by confirming who's present. The judge will likely ask whether you want to proceed with the injunction, to which you will say yes. The judge will also ask the other party if they object to the injunction. They usually say that they do object, and then you will have to have your hearing. Sometimes the other party will consent to the injunction without admitting anything, and then the judge will order the injunction without either party having to testify. Then you, the petitioner, go first and present your case. You'll explain what's been going on and testify about the history that you outlined in your petition. Even if it's already been included in the paperwork, you still have to discuss the incidents that have been listed so the judge can evaluate your credibility as to whether the incidents actually took place. This is your chance to present evidence, bring witnesses, and ask the judge for what you need. This is called an evidentiary hearing, meaning the judge can consider testimony, photos, text messages, and more. If you have an attorney with you, then you should have been prepared for the hearing and you should know what to expect. If you're representing yourself, I would suggest that you go back and watch the first 2 episodes of Litigation Corner, where we talk about self-representation. There are specific rules associated with evidence and how to get things like photographs admitted into evidence. But I want to highlight some of the information about evidence specific to these types of cases. You need to bring to the hearing everything that helps you tell your story. Let's start with text messages. Print the full conversation. Don't crop out parts of the conversation because then the judge may not be able to consider the evidence. You will want to bring up the conversation at a time logical to your story, and you will need to tell the judge that the text messages fairly and accurately depict the conversation. Next, let's talk about photographs. You would follow the same advice with respect to photographs as you would to text messages. If you have visible injuries or property damage, include photographs and say when and how they happened. Next, let's talk about witnesses. Friends, neighbors, or coworkers who saw or heard the abuse can come to court to support your story. Just be sure to let the judge know that they are there to let the court know what they saw or heard. Be sure to organize your documents in a folder. Use tabs or labels if you can. And practice what you'll say ahead of time, just like you would for a job interview or a speech. Also, keep a copy of your petition and attachments to the petition with you as well, in case you need to refer to anything. If you bring a witness to the courthouse, you'll need to ask them the questions. Sometimes a judge will ask the questions of the witness as well, but ultimately it's your responsibility to ask the questions. The judge knows that you are not an attorney, but there is a big rule the judge will expect you to follow. No leading questions. A leading question suggests the answer. For example, he hit me on March 2nd, didn't he? That's leading. Instead ask, what happened on March 2nd? Let your witness speak for themselves. Judges want clear, honest, direct testimony, not rehearsed stories. At the end of your hearing, the judge may ask how long you want the injunction to last. It could be 6 months, 1 year, 5 years, or more. Think about this in advance. If abuse has been long-term or severe, ask for a longer order. Explain how continued protection will help you move forward. If the judge grants the injunction, congratulations, you've taken a major step. The order will be entered into law enforcement databases and remain in effect until it expires, is changed, or is dismissed by the court. Now I want to address survivors directly. Let me say this clearly. You are a survivor. You do not deserve to live in fear of being abused or threatened. You're using the legal system to stand up for yourself. That's not just legal action. That's courage. You might feel afraid. You might doubt yourself. That's okay. But you don't need a law degree to be heard. You just need your truth and your voice. If you're listening and thinking, I don't think I can do this, let me tell you right now, you can. I've seen it happen for both people I've represented and for survivors representing themselves in court. You have a right to ask for protection. You have a right to tell your story, and you have the strength to survive and thrive. For this month's Good Story of the Month, we're going to talk about a story that's actually quite personal to me. Prior to working at Community Legal Services, I was a prosecutor, as I mentioned earlier. I worked as an assistant state attorney for the 7th Judicial Circuit. Part of my responsibilities was handling felony domestic violence cases. Right before I left the state attorney's office to join Community Legal Services, I was prosecuting a case in which a woman was abused, choked, and received some burns as a result of the attack. I'm going to call this woman Judy. Now, that's not her real name, but domestic violence survivors are often concerned about their stories being told because of their fear that the abuser might return. Judy gave me permission to tell her story. That case was ongoing when I left the state attorney's office, but was soon dropped by the state thereafter. What happened was that the abuser was continuing to have contact with Judy throughout the criminal process, even in violation of no contact orders. Eventually, the abuser convinced Judy to request dismissal of the case. Unfortunately, this is all too commonplace. I left the state to join Community Legal Services, as I talked about earlier. About 2 years after I left the state attorney's office, Judy became my client. At the time, she was still living with her abuser, this time through the height of the COVID-19 pandemic, and recognized that she needed help to get out of the situation. I encouraged her that help could come through the form of an injunction, that by filing for protection, we could get her out of the bad situation and we could force her abuser to leave her home. But filing an injunction was a difficult step for her to take. She was terrified of the idea of applying for the injunction and it being denied. She was also terrified of her abuser finding out that she asked for help. But I maintained a positive attitude and encouraged her, and told her that I would be there for her to handle the injunction hearing. Ultimately, she did a very brave thing, trusted the process, and filed her petition for an injunction. A temporary injunction was granted, and he was forced from the home. I attended the injunction hearing with her, prepared her for the hearing, and led her through a powerful direct examination in which she talked about the history of abuse that she had suffered. I even had the opportunity to cross-examine her abuser and get him to admit that he had previously violated the no-contact order in the criminal case. After listening to the evidence, the judge issued an injunction for protection to protect Judy for the next 5 years. And with that, she was able to get her abuser out of her life. I can tell you that it is really magical to see someone feeling relief after years of abuse. It was a wonderful moment knowing that what I wasn't able to accomplish as a prosecutor and what Judy wasn't ready to accomplish back then was able to be accomplished through the legal aid program like Community Legal Services. Thank you for joining this episode of Litigation Corner. I'm John Martino. Stay informed, stay strong, and stay safe. Until next time.